The county courthouse doors swung open, and Maya Simmons walked in carrying nothing but a worn manila folder. Lawyers in $1,000 suits barely glanced at her. Just another self-represented litigant who didn't know better. Across the aisle sat Ethan Blackwood, billionaire real estate mogul, flanked by elite attorneys who'd made careers out of making problems disappear. When he saw her sitting alone, his lips curled into a dismissive smile. This would be over before lunch. But there was something Blackwood hadn't bothered to learn about the quiet maid he'd fired and tried to erase. Maya had spent 6 months teaching herself the law with the same discipline her mother had taught her about survival. And today, Blackwood was about to learn that the most dangerous opponent isn't the one with money or power. It's the one with nothing left to lose. Just before we get back to it, I'd love to know where you're watching from today, and if you're enjoying these stories, make sure you're subscribed. The county courthouse buzzed with its usual Monday morning chaos. Lawyers in expensive suits strode confidently through the marble corridors, their leather briefcases gleaming under fluorescent lights. Court clerks shuffled mountains of paperwork between benches, their faces set in expressions of practiced indifference. Spectators whispered among themselves in the gallery, waiting for their cases to be called. Everyone here knew their role, understood the rhythm of the system, moved through it with the ease of repetition. Then she walked in. The woman was in her early 30s, black, with her hair pulled back into a neat bun that spoke of careful preparation. She wore a simple navy dress, clean but not expensive, and carried a single worn manila folder tucked under her arm. Her shoes were practical, slightly scuffed at the toes. Everything about her appearance was modest, unremarkable, the kind of person who usually sat in the back rows, waiting to pay a traffic ticket or contest a small claim. She moved through the courtroom entrance with quiet purpose, her eyes scanning the room until they found the plaintiff's table. That's when the whispers started. A bailiff near the door noticed her first. He was an older man with gray temples and kind eyes, the type who'd worked courthouse security for 20 years and could spot confusion from across a room. He approached her gently, his voice low and courteous. "Ma'am, are you looking for someone? Can I help you find your attorney?" She turned to him with a calm expression. "No, thank you. I'm here for my case." The bailiff's eyebrows lifted slightly. "Your case? And your lawyer is?" "I don't have one. I'm representing myself." The whispers grew louder. Heads turned. A few lawyers near the front exchanged glances, their expressions mixing curiosity with something closer to pity. Self-representation wasn't unheard of in small claims or traffic court, but this was the civil docket. Real litigation. The kind that required understanding of procedure, evidence rules, and legal strategy. The bailiff studied her face for a moment, clearly uncertain whether to press the issue, then simply nodded and stepped back. Courtroom 4. Judge Harrison presiding. "Good luck to you." She thanked him and walked to the plaintiff's table, setting her folder down with deliberate care. Around her, the courthouse continued its morning routine, but she'd already become a point of interest. Whispers followed her like a shadow. "Is she serious? This should be quick. Poor thing doesn't know what she's in for." The courtroom slowly filled. The judge's bench sat empty, waiting. The court reporter arranged her equipment with practiced efficiency. Spectators filtered into the gallery, some here for other cases, some drawn by the docket listings that had caught their attention. Then the atmosphere in the room shifted. The double doors at the back swung open, and Ethan Blackwood entered. He was impossible to miss. Late 40s, with silver threading through his dark hair in a way that made him look distinguished rather than old. His suit was charcoal gray, custom-tailored, probably worth more than most people earn in 3 months. He walked with the easy confidence of someone who'd never been told no, who'd never had to wait for anything, who understood that doors opened before he reached them. Behind him came his entourage. 2 attorneys, both partners at one of the city's most prestigious firms, their suits nearly as expensive as his. A paralegal carrying a leather attaché case. An assistant typing rapidly on a tablet. A security consultant who looked former military, his eyes constantly scanning the room. Blackwood moved down the aisle like he owned it. He probably did own buildings like it. His real estate empire stretched across 3 states, his name attached to luxury condos, commercial developments, and sprawling private properties that most people only saw in magazine spreads. He barely glanced around as he approached the defense table. His lead attorney, Marcus Pemberton, was already reviewing documents, his silver reading glasses perched on his nose. Pemberton had a reputation for destroying plaintiffs, for turning trials into demolitions, for defending corporations against accusations with surgical precision. Blackwood settled into his chair, adjusting his cuffs. Then, almost as an afterthought, his gaze drifted across the aisle. He saw her. His eyes lingered for just a moment, taking in a modest dress, the worn folder, the absence of any legal team. Then his lips curved upward just slightly. Not a full smile, but something closer to amusement. The kind of expression someone might make when they realize they've been worried over nothing. He leaned toward Pemberton, murmuring something too quiet for anyone else to hear. Pemberton glanced over, his own expression carefully neutral, but his eyes betrayed the same assessment. This wouldn't take long. The bailiff's voice rang out. All rise. The Honorable Judge Margaret Harrison presiding. Everyone stood as Judge Harrison entered. She was in her early 60s, with steel-gray hair cut short and sharp eyes that missed nothing. She'd been on the bench for 15 years, had seen every kind of case, every kind of lawyer, every kind of trick. She settled into her chair with the efficient movements of someone who'd done this thousands of times. Be seated. Her voice carried authority without volume. She opened the case file before her, scanning the documents with practiced speed. Case number 2024, CV 8847. Simmons versus Blackwood Holdings. Is the plaintiff present? The woman at the plaintiff's table stood. Yes, Your Honor. Maya Simmons. Judge Harrison's eyes lifted from the documents, studying her. Ms. Simmons, I see from the record that you filed a waiver of representation. You understand you're proceeding without legal counsel? Yes, Your Honor. And you understand that this court cannot provide you legal advice, that you'll be held to the same standards as any attorney, and that representing yourself puts you at a significant disadvantage? I understand, Your Honor. The judge's expression didn't change, but something flickered in her eyes. Not sympathy exactly, but a kind of weary recognition. She'd seen self-represented plaintiffs before. Most of them crashed and burned within the first hearing. Very well. Is the defense present? Marcus Pemberton rose smoothly. Yes, Your Honor. Marcus Pemberton of Pemberton, Chase and Associates, representing Blackwood Holdings and Mr. Ethan Blackwood personally. Thank you, counsel. Let's begin with a summary. Judge Harrison glanced back down at her file. Ms. Simmons, you're alleging wrongful termination, wage theft, intimidation, and coerced silence against Blackwood Holdings. These are serious accusations. Can you briefly outline the basis of your claims? Maya remained standing. Her voice was steady, clear, without the tremor of nervousness that usually marks self-represented plaintiffs. Your Honor, I was employed as a live-in domestic worker at Mr. Blackwood's private estate in Riverside County for approximately 18 months. During that time, I worked an average of 70 to 80 hours per week with no overtime compensation, no written contract, and payment exclusively in cash that fell below minimum wage standards. When I requested proper documentation and legal employment status, I was terminated immediately, evicted from the staff housing with 4 hours' notice, and subsequently found that negative references had been provided to potential employers. I have documentation supporting each of these claims. The courtroom was silent. Even the usual shuffling of papers had stopped. Judge Harrison's pen moved across her notepad. And your requested relief? Back wages calculated at proper rates, including overtime, compensation for constructive eviction, punitive damages for retaliation, and an injunction requiring Blackwood Holdings to provide accurate employment records. Pemberton was already on his feet. Your Honor, if I may, you'll have your turn, Mr. Pemberton. Judge Harrison's tone was mild but firm. She looked back at Maya. Ms. Simmons, these allegations, if proven, would constitute significant labor violations. The burden of proof is on you. Do you understand what that means? Yes, Your Honor. I need to prove each element of my claims by a preponderance of the evidence. Another flicker in the judge's eyes. That wasn't the answer of someone guessing. That was the language of someone who'd studied. Pemberton cleared his throat. Your Honor, the defense moves for immediate dismissal on multiple grounds. First, the plaintiff lacks the legal competence to properly prosecute this action. Second, her Her claims are without merit and constitute nothing more than a disgruntled former employee attempting to extort my client. Third, she has failed to properly serve notice under the required statutes. We request this matter be dismissed with prejudice. Maya spoke before the judge could respond. Your Honor, I filed proof of service 6 weeks ago. It's document 12 in the case file. Mr. Pemberton's firm acknowledged receipt on May 3rd. Pemberton's jaw tightened almost imperceptibly. He shuffled through papers, found the document, and his expression hardened. Judge Harrison glanced at her own file. Ms. Simmons is correct. Service was proper and timely. Your other grounds, Mr. Pemberton? Your Honor, this is a clear abuse of process. Ms. Simmons has no legal training, no understanding of civil procedure, and no business bringing claims of this magnitude without representation. Allowing this to proceed wastes the court's time and resources. What you're describing, Mr. Pemberton, is your opinion of the likely outcome, not grounds for dismissal. Judge Harrison looked at Maya. Ms. Simmons, do you have preliminary evidence supporting your claims that would survive a motion to dismiss? Yes, Your Honor. I have work logs, time-stamped photographs, witness statements, and financial records. Then this case will proceed. I'm setting a preliminary hearing for next week to review evidence and establish whether there's sufficient merit to move forward. Both parties will submit their evidence summaries by Friday. Ms. Simmons, you'll need to follow proper formatting. The clerk can provide you with examples. Pemberton's expression flickered with irritation. Your Honor, we respectfully request. Your request is noted and denied, counsel. Next week, 9 a.m. We're adjourned. The gavel came down with a sharp crack. The courtroom stirred back to life. Spectators began filing out, their whispers now tinged with surprise. This was supposed to have been over in minutes. Across the aisle, Ethan Blackwood leaned back in his chair, his expression unreadable. The small smile from earlier had vanished. Pemberton was already gathering documents, his movements sharp with frustration. They'd expected a quick dismissal. They prepared for it. Instead, they had a week to prepare for actual litigation. Maya collected her folder carefully, her hand steady. She didn't look at Blackwood, didn't acknowledge the stares from the gallery. She simply walked toward the exit with the same quiet purpose she'd shown walking in. As she passed through the doors, one of the spectators, a young law student observing for class credit, whispered to her friend, "She's either very brave or very stupid." Her friend, older and more cynical, shook her head slowly. Did you see how she answered? She knew the terminology. She knew where her documents were. I'm not sure which one she is yet. Outside the courtroom, Maya found a bench in the corridor and sat down. Her hands, which had remained steady throughout the hearing, trembled slightly now that no one was watching. She opened her folder and looked at the contents. Pages of notes, organized by date and category. Photographs printed from her phone, each one labeled. A list of names with contact information. Financial calculations done and redone until the math was perfect. She'd spent the last 6 months preparing for this. Every night after losing her job, after finding a tiny room in a boarding house that ate most of her savings, after sending out job applications that went nowhere because someone had made sure her references were poisoned, she'd spent those nights studying. The public library had been her law school. Free legal databases, her textbooks. Court observation videos online, her professors. She'd watched hundreds of hours of real trials, taken notes on procedure, learned the language not from theory but from practice. She'd known from the beginning that no lawyer would take her case. She tried 15 firms. Some had been honest about it, explaining that Blackwood's reach made it professional suicide. Others had simply said they were too busy, or her case wasn't strong enough, or she should just move on. One attorney, an older woman with tired eyes, had pulled her aside after a consultation. Honey, I believe you. I believe every word. But Ethan Blackwood destroys people who cross him. He has lawyers on retainer who do nothing but make problems disappear. Your problem. If I take your case, I become a problem. I have a family. I have a mortgage. I am sorry. Maya had thanked her for the honesty and left. That night, she'd made her decision. If no one would fight for her, she'd fight for herself. Her phone buzzed. A text from an unknown number. You should drop this while you still can. She deleted it without responding. It wasn't the first. It wouldn't be the last. The week passed in a blur of preparation. Maya worked her part-time job at a grocery store during the day, stocking shelves and running registers for $9 an hour. Her coworkers knew nothing about her case. To them, she was just another employee, quiet and reliable, someone who showed up on time and never complained about the schedule. During her breaks, she'd sit in her car in the parking lot, reviewing legal procedure on her phone, memorizing terminology, studying case law examples from free legal databases. The nights were longer. Her room in the boarding house was small, barely large enough for a twin bed, a rickety desk, and a narrow closet. The walls were thin enough that she could hear Mrs. Chun in the next room watching television. Hear the couple upstairs arguing about bills. Hear the midnight footsteps of the night shift worker down the hall coming home. But none of that mattered when she was working. She'd spread her documents across the desk, her laptop open to legal formatting guides, her phone propped up playing quiet instrumental music to help her focus. Every claim in her case had to be supported by evidence. Every piece of evidence had to be properly labeled, dated, and referenced. The court wouldn't accept sloppy work just because she wasn't a lawyer. By Wednesday night, her evidence summary was taking shape. 47 pages of carefully organized information. Each claim linked to specific documents. Each document explained in plain language. She'd learned that judges appreciated clarity over complexity, that being straightforward was better than trying to sound like a lawyer. Thursday morning, she'd gone to the courthouse early. The clerk's office opened at 8, and she wanted to make sure her formatting was correct before the Friday deadline. Patricia, the clerk, had been there sorting through the morning's filings. Patricia was in her 50s. With graying blonde hair, she wore a practical bun and reading glasses on a chain. She'd worked at the courthouse since she was 23. When Maya had approached her desk with her draft summary, Patricia had looked up with the expression of someone expecting another poorly prepared filing. Then she'd started reading. After a few minutes, Patricia had looked up, her expression different. "You formatted this correctly. I followed the examples you gave me. People always say that. Then they turn in garbage." Patricia flipped through more pages. "This is actually good." Maya had felt something loosen in her chest. She'd spent so many hours worrying that her lack of legal training would be immediately apparent. Most people who try this give up after the first hearing, Patricia had said quietly, glancing around to make sure no one was listening. She wasn't supposed to give advice, wasn't supposed to help one side over another. But there was something in her voice that suggested she'd bent that rule before. "But you made it through. That's something." Maya had smiled without humor. Making it through one hearing isn't the same as winning. "No," Patricia had agreed, pushing her reading glasses up her nose. "But it's not losing either. And between you and me, I've been doing this job for 27 years. I've seen a lot of people walk through those doors thinking they'll get justice. Most of them don't. But every once in a while, someone comes along who actually does their homework. Someone who treats the system with respect, even when the system hasn't respected them. Those people, they have a shot." She'd stamped Maya's evidence summary with a filing date. Good luck in there. Maya had carried those words with her through Friday, through the weekend, through Sunday night when anxiety had kept her awake. She'd gotten up at 6 anyway, showered in the shared bathroom down the hall, pressed her navy dress, and prepared herself for round 2. The following Monday arrived. Maya entered the courtroom with the same worn folder, now thicker with additional documents. The gallery was more crowded this time. Word had spread about the Maid suing Blackwood without a lawyer. Some people were here out of curiosity. Others, perhaps, out of something closer to hope. Blackwood arrived exactly as before, but this time his expression held no amusement. He looked irritated, like someone forced to deal with a problem that should have already been resolved. Pemberton and his team carried multiple file boxes this time, wheeling them in on a handcart. The message was clear. They were going to bury her in paperwork. Judge Harrison called the court to order and reviewed the submitted evidence summaries. Maya had submitted 47 pages. Blackwood's team had submitted 612. Pemberton rose smoothly. "Your Honor, the defense has provided comprehensive documentation demonstrating that Ms. Simmons' employment was entirely voluntary, appropriately compensated for the work performed, and terminated only after repeated performance issues and violation of estate security protocols. We've included testimony statements from other staff members, financial records showing proper compensation, and evidence of Ms. Simmons' own misconduct. He spoke with the easy confidence of someone who'd done this 1,000 times, using complex legal language designed to overwhelm anyone not trained in law. Judge Harrison turned to Maya. Ms. Simmons' response? Maya stood. Your Honor, I request that the defense specify which documents in their submission directly contradict the time logs I provided from March 15th through March 30th of last year. Pemberton blinked. That wasn't how self-represented plaintiffs usually responded. They usually tried to argue generally, emotionally. They didn't request specific citations. Your Honor, Pemberton said smoothly, our submission is comprehensive. We're not required to. Actually, Mr. Pemberton, if Ms. Simmons has requested specific documentation and you've submitted 600 pages, the court would appreciate some guidance. Judge Harrison's tone was neutral, but her meaning was clear. Pemberton's associate began flipping through file boxes. Minutes passed. The courtroom waited in awkward silence. Finally, Pemberton cleared his throat. Your Honor, those specific dates are addressed in Section 7, subsection C, documents 347 through 351. Maya didn't even open her folder. Your Honor, those documents are payroll summaries for the main household staff. I wasn't on that payroll. I was paid separately in cash, specifically to avoid documentation. That's part of my claim. Judge Harrison leaned forward slightly. Mr. Pemberton? Your Honor, the defense maintains that Ms. Simmons was properly compensated through alternative means that were appropriate for her position. Alternative meaning cash payments with no records? The judge's eyebrow lifted. Records exist, Your Honor. They're simply maintained through a different accounting system for contract workers. Maya spoke again. Your Honor, I request those contract worker records be provided, including contracts showing my agreed compensation rate and hours. The silence that followed was heavy. Pemberton's expression tightened. Your Honor, we'll need time to retrieve those specific documents from our client's archives. How much time, counsel? 2 weeks would be appropriate. Judge Harrison made a note. You have 1 week. Ms. Simmons, anything else? Yes, Your Honor. I'd like to address the defense's claim about my termination being related to security violations. They reference this in their summary, but provide no specific incidents, dates, or evidence. Pemberton interrupted. Your Honor, those details involve sensitive security protocols that cannot be disclosed in open court. Then file them under seal for the court's review. Judge Harrison said simply. You have the same deadline. 1 week. For the first time, Ethan Blackwood leaned forward in his seat. His jaw was tight, his hands clasped on the table in front of him. This wasn't going the way it was supposed to. The maid was asking the right questions. His expensive lawyers were scrambling. Pemberton tried another approach. Your Honor, the defense renews its motion to dismiss based on the plaintiff's clear inability to properly prosecute this action. Her questions, while seemingly specific, demonstrate a fundamental misunderstanding of legal procedure and burden of proof. Judge Harrison looked at Maya. Ms. Simmons, do you understand what Mr. Pemberton is arguing? Yes, Your Honor. He's arguing that because I don't have a law degree, I can't possibly know what I'm doing. But the questions I'm asking are simple. Where are the records proving I was properly paid? And where's the evidence of the security violations that supposedly justified firing me? Those aren't complicated legal concepts. Those are basic facts. Several spectators in the gallery nodded almost unconsciously. Judge Harrison's expression remained neutral, but something flickered in her eyes again. The motion to dismiss is denied. This case will proceed to discovery. Both parties will exchange relevant documents within 2 weeks. Mr. Pemberton, that includes the contract worker records and security incident reports. Ms. Simmons, you'll provide any additional evidence supporting your wage theft and wrongful termination claims. Discovery scheduled to be set at our next hearing. The gavel came down. As the courtroom cleared, Blackwood stood abruptly, his chair scraping loudly against the floor. He strode out without looking at anyone, his entourage scrambling to follow. In the corridor outside, his voice carried back through the doors before they fully closed. This was supposed to be over already. Pemberton's response was too quiet to hear, but his tone was defensive. Maya gathered her folders slowly, deliberately. Her heart was pounding, but her hands were steady now. She'd survived another hearing. More importantly, she'd forced them to produce evidence they hadn't wanted to provide. She'd made them scramble. A court reporter approached her as she walked toward the exit. "Ms. Simmons, I'm with the Metro Daily. Would you be willing to answer a few questions about your case?" Maya shook her head politely. "No comment. Thank you. People are starting to follow this story. The maid taking on a billionaire. It's compelling. It's not a story," Maya said quietly. "It's my life." She walked away before the reporter could respond. Outside, the afternoon sun was bright and warm. Maya found a bench near the courthouse steps and sat down, finally allowing herself to breathe. She pulled out her phone and looked at her notes app, where she'd been tracking everything. Hearing 1, survived initial dismissal. Hearing 2, forced document production. 2 small victories. But she knew what they didn't yet. She knew that the documents they were going to have to produce would reveal more than they realized. She knew because she'd kept her own copies of everything. When she'd worked at Blackwood's estate, she'd been careful. Every night before bed, she'd photographed her handwritten work logs. She'd backed them up to a cloud service using the estate's guest Wi-Fi. She'd saved every text message about schedule changes. She'd kept every cash payment envelope and photographed them with timestamps. She'd done it because she'd seen what happened to Maria. Maria had been another maid, older, with 3 children and a husband who was sick. Maria had worked at the estate for 5 years. When one of Blackwood's business partners had gotten too friendly with her, had cornered her in a hallway, had made it clear that refusing him would mean losing her job, Maria had reported it. She was fired the next day. Not just fired, erased. Her employment records vanished. Her references were poisoned. Within 2 months, she'd lost her apartment. Last Maya had heard, Maria was working 3 part-time jobs and living in her car. That's when Maya had started documenting everything. She hadn't planned to sue. She just wanted protection, insurance against the possibility that something might go wrong. She'd seen how the estate operated, how staff were treated as invisible until they became inconvenient. She'd watched people get fired without explanation, without documentation, without recourse. The estate ran on cash payments and verbal agreements, on the understanding that asking questions meant losing your position. Maya had needed the job desperately when she'd first been hired. Her mother's medical bills had been crushing them both. The live-in position meant no rent, 3 meals a day, and enough cash payment to cover her mother's medications and therapy appointments. She told herself she could handle the long hours, the lack of official employment, the way Blackwood's head of household staff spoke to her like she was less than human. It was temporary, just until her mother was stable. Then her mother had died anyway. Heart failure, sudden and complete, 3 months into Maya's employment at the estate. Maya had been granted exactly 1 day off for the funeral. She'd come back the next morning to find her room had been inspected, her belongings searched, her phone confiscated for security protocols during her absence. They'd returned it 6 hours later with no explanation. That's when the documentation had started. That's when she'd realized this job wasn't temporary. It was a trap. But when they'd fired her the same way they'd fired Maria, when they tried to erase her employment the same way, when she'd realized that silence meant disappearing completely while Blackwood continued doing this to person after person, she'd made a different choice. Her mother had spent her whole life being silent, accepting less, staying quiet to keep the peace. Maya had held her mother's hand in that hospital room and promised her something different. She promised to be loud. Her phone buzzed again. Another unknown number. "You're making a mistake. This will destroy you." She stared at the message for a long moment, then deleted it. They were trying to scare her. They'd been trying since the beginning. What they didn't understand was that she was already scared. She'd been scared every day for the last 6 months. Fear wasn't new. Living with fear while doing it anyway. That was the skill she'd learned. She stood up, adjusting her bag on her shoulder, and walked toward the bus stop. She had a shift at the grocery store in an hour. After that, she'd spend the night preparing for the next phase, organizing the documents they didn't yet know she had, anticipating the next move in a game she was learning as she played. The document deadline came and went. On the morning it was due, Pemberton's team filed a motion requesting an extension. Technical difficulties, they claimed. Archive access issues. The judge denied it within an hour and imposed a penalty. If the documents weren't submitted by end of business that day, The court would accept Maya's version of events as factual record. Maya had been restocking canned goods at the grocery store when her phone buzzed with a court notification. She'd read it twice, standing in the middle of aisle 7 with a price gun in her hand, hardly believing what she was seeing. The judge was holding them accountable. By 4:30 that afternoon, a courier delivered 6 boxes of documents to the courthouse. Maya received the notification and requested copies. The clerk's office would have them ready by morning. That night, she barely slept. Not from anxiety this time, but anticipation. She knew what those documents would show because she knew what they couldn't hide. The next morning, she arrived at the courthouse at 7:30. Patricia was already there, as always, sorting through the early filings. When she saw Maya, she gestured toward a back table where the copied documents waited. 6 boxes, Patricia said quietly. That's a lot of paper to hide very little truth. Maya spent 4 hours going through everything. Most of it was irrelevant. General payroll records, routine HR policies, standard employment contracts for regular staff. Buried in box 4, she found what mattered. A single folder labeled Contracted Services, Residential Properties. Inside were payment logs, cash disbursements, names, dates, amounts. The amounts were consistently below minimum wage when calculated against standard work hours. But there were no work hours listed. No contracts. No agreements. Just payments marked household assistance and property services. Her name was there. 18 months of payments. Every one of them exactly what she remembered receiving. Every one of them insufficient for the hours she'd worked. But more importantly, there were other names. Dozens of them. Some she recognized from her time at the estate. Others she'd never met. The pattern was unmistakable. Blackwood had been doing this for years. She photographed every page. The hearing was scheduled for 2 o'clock. Maya arrived early, her folder now containing the photographs and her analysis. The gallery was more crowded than before. She recognized a few faces, reporters, mostly, along with some legal observers and a handful of people who looked like they might be former estate employees. Blackwood arrived exactly at 1:55, cutting it close. His expression was hard, his jaw tight. Pemberton looked worse. There were shadows under his eyes, and his usual polish seemed dimmed. They'd had a difficult week. Judge Harrison called the court to order and looked directly at the defense table. Mr. Pemberton, the court has reviewed your submitted documents. I have questions. Pemberton stood. Of course, Your Honor. These payment logs in box 4. They list cash disbursements to individuals identified only by first names and last initials. No contracts. No hour records. No tax documentation. Can you explain the system? Your Honor, those payments were for contracted services rendered by independent contractors who preferred cash payment arrangements. This is not uncommon in residential property management. Independent contractors, the judge repeated slowly. Ms. Simmons, you were listed in these logs. Were you operating as an independent contractor? Maya stood. No, Your Honor. I was a live-in employee. I worked a set schedule, took direction from household staff, wore a uniform provided by the estate, and had no control over my work hours or duties. Under federal labor law, that's an employee, not an independent contractor. Judge Harrison nodded. That's my understanding as well. Mr. Pemberton, do you have any contracts establishing these individuals as independent contractors? Your Honor, many of these arrangements were made verbally. So the answer is no. The judge made a note. Ms. Simmons, you've alleged a pattern of labor violations. Based on these documents, do you wish to amend your complaint? This was the moment. Maya had prepared for this exact question. Yes, Your Honor. I'd like to request class certification. These documents show that Blackwood Holdings engaged in systematic wage theft affecting multiple employees over several years. I believe this qualifies for class action status. The courtroom went dead silent. Pemberton's face drained of color. Blackwood leaned forward, his hands gripping the table edge. A class action would mean dozens of plaintiffs, millions in potential damages, and most importantly, a level of public scrutiny that would devastate his business empire. Your Honor, Pemberton said, his voice sharp, this is highly irregular. Ms. Simmons is not qualified to serve as class representative. She has no legal training, no resources to manage a class action, and frankly, this appears to be a transparent attempt to extract a settlement through intimidation. Is it working? Judge Harrison's expression didn't change, but there was something almost amused in her tone. Ms. Simmons, do you understand what class certification requires? Yes, Your Honor. I need to prove commonality, that the class members share common questions of law or fact. I need to show typicality, that my claims are typical of the class. I need to demonstrate adequacy, that I can fairly represent the class interests. And I need to show numerosity, that the class is large enough that individual lawsuits would be impractical. The judge studied her for a long moment. You've done your homework. I had to, Your Honor. Mr. Pemberton, does your client wish to respond to this request before I make a ruling? Pemberton and Blackwood huddled together, their conversation intense and whispered. Blackwood's hand chopped through the air, emphasizing points. Pemberton shook his head, then nodded reluctantly. The discussion stretched to 3 full minutes, the courtroom waiting in tense silence. Finally, Pemberton straightened, tugging his suit jacket back into place. Your Honor, my client would like to propose a settlement discussion, a private mediation session to resolve this matter without further litigation. We're prepared to offer substantial compensation to Ms. Simmons in exchange for a confidential resolution. Judge Harrison's eyebrow lifted slightly. Ms. Simmons? Maya didn't hesitate. I decline, Your Honor. The murmurs in the gallery were louder this time, people leaning toward each other in surprise. Reporters shifted in their seats, pens moving rapidly across notepads. Even the bailiff looked surprised, his usual impassive expression cracking just slightly. You decline? Pemberton's voice was sharp with disbelief, his professional composure slipping. Ms. Simmons, you're being offered an opportunity to resolve this case with guaranteed compensation. Substantial compensation, I might add. You're refusing that. I am. Pemberton spread his hands in a gesture that seemed designed for the gallery as much as the judge. Your Honor, may I ask Ms. Simmons to clarify her reasoning? We're offering her a path to financial security, to resolution, to moving forward with her life. I'm struggling to understand why anyone would refuse such an offer unless, he paused meaningfully, unless there are other motivations at play here. Judge Harrison's expression cooled. Mr. Pemberton, are you implying something about Ms. Simmons' integrity? I'm merely pointing out, Your Honor, that rejection of a reasonable settlement suggests this case may be about something other than justice. Perhaps publicity, perhaps political activism. Perhaps. I'll tell you what it's about, Mr. Pemberton. Maya's voice cut through his speculation. She hadn't meant to interrupt, hadn't planned this moment, but the words came anyway. Maya turned to face him directly. Because this isn't about me anymore, Mr. Pemberton. It's about Maria, who lost her job and her home when she reported harassment. It's about James, whose name is in those payment logs, who worked 70-hour weeks for 5 years and was fired when he asked for proper documentation. It's about every person who thought they had no choice but to stay silent because one man had enough money and power to make them disappear. Her voice was steady, clear, carrying to every corner of the courtroom. You're offering me money to be quiet. That's what you always do. That's what this whole system is designed to do. Pay just enough to make the problem go away, but not enough to change anything. I'm not interested in going away. The silence that followed was profound. Even Pemberton seemed at a loss for words, his mouth opening and closing without sound. Judge Harrison remained perfectly still, her expression unreadable, but her eyes never left Maya's face. In the gallery, one of the older women, someone Maya recognized from the payment logs, a housekeeper named Dorothy who'd worked for Blackwood 6 years ago, was crying quietly, her hand pressed to her mouth. Next to her, a younger man nodded slowly, his jaw set. Blackwood's face had gone pale, then flushed red. His hands gripped the table edge so tightly his knuckles were white. For a moment, Maya thought he might stand up, might say something, might lose control entirely. But he remained seated, though everything about his posture screamed fury. Judge Harrison leaned back in her chair, studying Maya with an expression that was impossible to read. Finally, she spoke. Ms. Simmons, I'm going to be direct with you. Class action litigation is complex, expensive, and time-consuming. It requires resources you don't have. It requires legal expertise you don't possess. Even with the strongest case, you would be at a severe disadvantage. Are you certain you want to proceed down this path? I am, Your Honor. Then I'm going to make an unusual ruling. The judge looked at both tables. I'm granting preliminary approval for class certification, pending proper notice to potential class members and a formal adequacy hearing. However, I'm also going to strongly suggest that Ms. Simmons seek pro bono legal counsel. There are organizations that handle class action labor cases. I'll provide a list. Pemberton was on his feet. Your Honor, this is... Careful, counselor. Judge Harrison's voice was quiet but edged with steel. I've reviewed the evidence. I've seen the pattern. Your client has been operating a system designed to exploit vulnerable workers for years. The fact that Ms. Simmons is representing herself doesn't change the underlying facts. If anything, it makes them more troubling. She looked back at Maya. You've survived this long on preparation and determination. But this next phase will be harder. I am ordering expedited discovery. Both parties will have 3 weeks to gather evidence. We'll reconvene for the adequacy hearing on November 15th. In the meantime, Mr. Pemberton, your client is not to contact any potential class members. No settlements, no NDAs, no communication of any kind. Are we clear? Yes, Your Honor. Pemberton's voice was tight. Ms. Simmons? Yes, Your Honor. Thank you. The gavel came down. As the courtroom emptied, Maya gathered her folder slowly. Her hands were shaking now, the adrenaline finally catching up with her. She'd done it. She'd actually done it. The case was moving forward, expanding, becoming something bigger than she'd imagined when she first walked through these doors. A voice spoke behind her. Miss Simmons. She turned to find a woman in her 40s, professionally dressed, with sharp eyes and a kind smile. I'm Rachel Winters. I'm with the Workers' Justice Coalition. We're a nonprofit that handles labor cases. I've been watching your case, and I'd like to talk to you about representation. Maya blinked. You want to represent me? We want to work with you. Rachel corrected. You've gotten further than most lawyers would have. You've built something real here. But the judge is right. This next phase requires resources and expertise. We could provide both. You'd still be the lead plaintiff. You'd still have control over strategy. But you wouldn't be alone anymore. For the first time in months, Maya felt tears prick at her eyes. She blinked them back. I can't pay you. We don't charge clients. That's what pro bono means. Rachel handed her a business card. Think about it. Call me when you're ready. But don't wait too long. We have a lot of work to do. Maya took the card with trembling fingers. Thank you. After Rachel left, Maya sat down at the plaintiff's table again, alone in the empty courtroom. The afternoon sun streamed through the high windows, casting long shadows across the wooden benches. She thought about her mother, about Maria, about all the people whose names were in those payment logs. Her phone buzzed. Another unknown number. She almost didn't look, expecting another threat. But this message was different. Thank you for not giving up. You don't know me, but I worked at the estate 3 years ago. They did the same thing to me. I'm ready to testify if you need me. Then another. I saw the news. I was there too. Count me in. And another. My sister worked for Blackwood. She never told us what happened. Now I understand. How can we help? Maya stared at her phone as more messages came in. People were watching. People were listening. People were ready to speak. She wasn't alone anymore. Outside the courthouse, Ethan Blackwood sat in the back of his Mercedes, his phone pressed to his ear. Rain drummed against the roof, streaking down the tinted windows in rivers. His voice was low, controlled, but anyone who knew him would recognize the fury underneath. The kind of cold rage that made executives resign and business partners reconsider their alliances. I don't care what it costs. Find out who's behind her. Nobody prepares like that without help. Nobody knows those laws without coaching. Somebody is funding this. Somebody is pushing this. And I want to know who. His free hand drummed against his knee, a rare tell of his agitation. On the other end, his head of security responded with questions, with concerns about legal boundaries. Blackwood listened, his jaw working, his patience wearing thin. Then dig deeper. I want her financials. I want her phone records. I want to know everyone she's talked to in the last 6 months. I want to know where she lives, where she works, who she cares about. Everything. He ended the call and stared out the window at the courthouse, watching people file out through the rain, umbrellas blooming like dark flowers. The maid had just made the biggest mistake of her life. She thought she was brave. She thought she was righteous. She had no idea what he was capable of when someone threatened everything he'd built. His phone rang again, the screen displaying his corporate counsel's name. Blackwood stared at it for 3 rings before answering, already knowing this would be bad news. Nothing good came from lawyers calling immediately after a hearing loss. "Ethan, we need to talk. The labor board just opened an inquiry. So did the state tax authority. They're requesting employment records going back 5 years. Comprehensive records, payroll, tax filings, worker classifications, everything." Blackwood's blood went cold. The rain outside seemed to grow louder, or maybe it was just the rushing sound in his ears. How did they? Someone filed complaints. Multiple someones. I'm getting calls from former employees, current employees, people I've never heard of. They're all saying the same things your maid is saying. This is spreading, Ethan. This is metastasizing. The lawyer's voice cracked slightly on the last word. Fix it. I can't fix it. This is a regulatory investigation now. This is government agencies with subpoena power. If they find what I think they're going to find, we're looking at fines in the millions. Possibly criminal charges for tax evasion. They're taking this seriously, Ethan. Very seriously. Criminal charges? Blackwood's voice was deadly quiet, each word measured and precise. You pay people off book for years. No paro taxes. No unemployment insurance. No workers' comp. The IRS doesn't care if you're a billionaire, Ethan. They care about unpaid taxes. And right now, with all this publicity, they're going to want to make an example. You're the perfect target. High profile, wealthy, vulnerable. Blackwood ended the call without responding, his thumb pressing the red button with more force than necessary. He sat in silence, his mind racing through scenarios, through solutions, through ways to contain this disaster. The car felt smaller suddenly, the air thicker. The maid was supposed to be easy. She was supposed to be scared, overwhelmed, broken by the first hearing. She was supposed to disappear like all the others had. Instead, she'd become a problem that was metastasizing, spreading through his business empire like poison through veins. His driver glanced in the rearview mirror. "Where to, sir?" Blackwood didn't answer immediately. He was thinking about the courtroom, about the way that maid, Maya, her name was Maya Simmons, had looked at him when she refused the settlement. There hadn't been triumph in her eyes. There hadn't been anger. There had been something worse. Certainty. She'd known this was coming. She'd planned for it. Every move she'd made had been calculated to reach exactly this point. For the first time in his adult life, Ethan Blackwood felt something he hadn't experienced in decades. Genuine fear. "Sir," the driver prompted. "Home," Blackwood said finally. "I need to think." As the car pulled away from the courthouse, neither Blackwood nor his driver noticed the reporter standing on the courthouse steps, camera in hand, watching the car disappear into traffic. She was already typing notes in her phone, already sketching out the story that would run in tomorrow's morning edition. The headline was writing itself. The maid who took on a billionaire and won the first round. 3 weeks passed in a blur of preparation. Maya accepted Rachel Winter's offer, and suddenly she had a team. Not just Rachel, but 2 associate attorneys, a paralegal, and an investigator who specialized in corporate malfeasance. They set up in a donated office space, converted a conference room into a war room, and began the systematic work of building a class action case. Maya still worked her shifts at the grocery store. She needed the income, needed the routine, needed the reminder that she was still the same person who'd walked into that courthouse alone. But her nights were different now. Instead of studying alone in her boarding house room, she sat in strategy sessions, learning from lawyers who actually wanted to teach her, who respected what she'd accomplished. The investigator, a former FBI agent named Marcus Webb, had been the one to connect the dots. "Your instinct was right," he'd told her during their second meeting. "Blackwood's been doing this for at least 8 years. We've identified 47 potential class members so far. Some are still employed, some are terminated like you. All of them paid off book, all of them worked excessive hours, all of them threatened or intimidated into silence. How did he get away with it for so long?" Maya had asked. Marcus had smiled grimly. Money and fear. He paid enough that people felt like they couldn't leave, but not enough that they could save anything. And he made sure everyone knew what happened to people who complained. "Your friend Maria?" She wasn't the first. We've found 3 others who reported problems and were systematically destroyed, fired, evicted, blacklisted. One ended up homeless. Another left the state entirely. Can they testify? They're willing to. Now that you've shown it's possible to fight back, people are finding courage they didn't know they had. The adequacy hearing arrived faster than Maya expected. November 15th came with cold rain and gray skies. The courthouse was more crowded than ever. Media vans lined the street, reporters clustered under umbrellas, and the gallery was packed with spectators and potential class members who'd come to watch. Maya wore the same navy dress. It felt like armor now. Blackwood arrived with an even larger legal team. Pemberton had been joined by 2 additional partners and what looked like a crisis management consultant. Their strategy was clear: overwhelm with volume, confuse with complexity, and paint Maya as an opportunist exploiting a legal technicality. Judge Harrison called the hearing to order. We're here to determine whether Ms. Simmons can adequately represent the proposed class. Mr. Pemberton, you may present your objections. Pemberton stood, and for the next hour, he argued. Maya was unqualified. She had conflicts of interest. She was being manipulated by advocacy groups with political agendas. She couldn't possibly manage the complexities of class litigation. On and on, each argument more desperate than the last. When he finished, Judge Harrison turned to Rachel Winters. Counsel for the plaintiff? Rachel rose smoothly. She was everything Maya wasn't: polished, experienced, commanding. But when she spoke, she didn't talk about herself. She talked about Maya. Your Honor, Ms. Simmons has already proven her adequacy. She filed this case alone, represented herself through multiple hearings, uncovered evidence that multiple law firms missed or ignored, and forced one of the wealthiest men in this state to actually follow the law. She didn't do it with money or connections or prestigious degrees. She did it with preparation, courage, and an intimate understanding of the harm these workers suffered, because she lived it. Rachel gestured to the gallery, where dozens of former employees sat watching. These people trust her, not because she's a lawyer, but because she's one of them, because she stood up when no one else would. That's what adequacy means, Your Honor. Not perfection, not credentials. The willingness to fight for people who can't fight for themselves. The judge was quiet for a long moment. Then she spoke. Ms. Simmons, please approach. Maya stood and walked to the podium, her heart pounding. I've been on this bench for 15 years, Judge Harrison said. I've seen thousands of cases, thousands of attorneys. Most of them are competent. Some are brilliant. But very few of them show the kind of determination you've demonstrated. However, determination isn't enough for what comes next. This case will be attacked from every angle. Your character will be questioned. Your motives will be challenged. Your every decision will be scrutinized by lawyers who get paid more in a day than you probably earn in a month. Can you handle that? Maya met her eyes. Your Honor, they've already been doing that since day one. I'm still here. Something shifted in the judge's expression. Not quite a smile, but close. Yes, you are. She looked out at the courtroom. I'm granting class certification. Ms. Simmons will serve as lead plaintiff with Rachel Winters of the Workers' Justice Coalition as class counsel. Notice will be sent to all potential class members. We're moving to trial. Discovery deadline is January 15th. Trial date is set for March 3rd. The gavel came down, and the courtroom erupted. Maya stood frozen at the podium, unable to quite believe what had just happened. Rachel touched her shoulder, grinning. We did it. You did it. Across the aisle, Blackwood stood abruptly and walked out without a word, his legal team scrambling to follow. His face was completely expressionless, but his hands were clenched into fists. As Maya walked out of the courtroom, reporters surrounded her with questions. She prepared a statement with Rachel's help, something brief and measured. But when she opened her mouth, different words came out. I'm not doing this because I hate Ethan Blackwood. I'm doing this because I love the people who deserve better. That's the difference between us. That night, her words were everywhere. Local news, social media, even a mention on a national news segment about labor rights. The story was no longer about a maid suing a billionaire. It was about power, justice, and what happens when someone refuses to disappear. Maya sat in her boarding house room, watching coverage on her laptop, her phone buzzing with messages of support from people she'd never met. The trial was still months away. The hardest part was still ahead. But for the first time since she'd filed that initial complaint, she felt something she hadn't allowed herself to feel before. Hope. The morning after class certification, Maya's phone rang at 6:30. Unknown number. She'd learned to answer them anyway. Ms. Simmons? I am Jennifer Calvel. I worked at the Riverside Estate 4 years ago. I need to tell you what happened to me. By the end of the week, Marcus Webb's investigation had identified 73 potential class members. Each one had been silenced. The Workers' Justice Coalition rented a larger office space. Rachel brought in 2 more attorneys and a victim advocate. The war room expanded, walls covered with timelines and organizational charts. He's got 17 properties, Marcus explained, pointing to a map. We found evidence of labor violations at 12 of them. This is systematic. Maya studied the map, recognizing some locations. The Riverside Estate where she'd worked. The downtown high-rise where she'd heard other maids worked. The beach house that required year-round staff. How did he think he'd never get caught? Because he never had been, Rachel said simply. Rich people break labor laws all the time. Most workers don't report it because they're afraid of retaliation. The ones who do report it usually can't afford lawyers, and the system grinds them down. Blackwood's been doing this for years because the system let him. Until now, one of the associate attorneys added. Until now, Rachel agreed, looking at Maya. You changed the equation. But Blackwood wasn't accepting change quietly. 3 days after the hearing, Maya's landlord called. I'm going to need you to vacate by the end of the month. I'm selling the building. Maya had been folding laundry. She stopped. You never mentioned that before. It just came up. Maya knew immediately. Someone had gotten to him. How much did they pay you? The landlord hung up. That evening, Maya sat in Rachel's office. I have 3 weeks to find a new place. Rachel made a call, then returned. My friend has a studio apartment. Below market rate. You can move in this weekend. I can't afford. The coalition is covering it. This is retaliation. Rachel's expression was firm. We protect our clients. I'm not a charity case. You're experiencing illegal retaliation from a billionaire. There's a difference. Rachel sat down. This will get worse. Blackwood will come at you with everything. Your job, your housing, your reputation. I know. Knowing it and living through it are different things. Maya met her eyes. I walked into a courthouse alone to face a man who could buy this building without noticing. I know what pressure feels like. Rachel studied her for a long moment, then nodded. Yeah, I think you do. The attacks continued. A week later, Maya's manager at the grocery store called her to his office. Corporate is concerned about the publicity. They're reducing your hours to 4 a week. That's the same as firing me. I know. I'm sorry. Maya cleared out her locker. In the parking lot, she called Rachel. Document everything. This is retaliation. Rachel paused. Is it working? Maya watched other employees living their normal lives. No. Good. Because we just got the discovery documents. They're devastating. For him, not us. The discovery revealed everything. Employment records going back a decade, showing a pattern so clear even Pemberton's legal team couldn't obscure it. Hundreds of workers paid off the books. Systematic wage theft calculated in the millions. Internal emails discussing how to manage difficult employees through intimidation and blacklisting. But the most damning evidence came from an unexpected source. A financial audit Blackwood had commissioned 3 years ago. His own accountant had warned him that his labor practices were illegal, that he was exposing himself to massive liability. Blackwood's response, preserved in email, was devastating. Handle it quietly. Make sure nobody talks. This is consciousness of guilt, Rachel explained during a team meeting. He knew what he was doing was illegal, and he did anyway. That makes our case for punitive damages exponentially stronger. Marcus added more evidence to the growing pile. We've also got testimony lined up from 14 former employees. Each one corroborates the pattern. Several of them kept documentation similar to Maya's. This isn't he said, she said anymore. This is overwhelming proof of systematic exploitation. Trial preparation consumed December and January. Maya spent her days in the coalition office, working with a legal team to organize evidence, prepare testimony, and coordinate with class members. Without her grocery store income, she was entirely dependent on the small living stipend the coalition provided. It was humbling, but also freeing. For the first time since she'd filed the lawsuit, she could focus entirely on the case without worrying about covering her basic expenses. She also studied relentlessly. Rachel gave her law books to read, explaining trial procedure, evidence rules, witness examination techniques. You won't be questioning witnesses, Rachel explained one evening over takeout Chinese food in the conference room. That's my job, but you're the lead plaintiff. The jury needs to see you understand this case, that you're not just a face we're putting forward. You need to know the law as well as any attorney in that courtroom. I want to testify, Maya said. That's assumed. Blackwood's team will cross-examine you hard. They'll try to tear you apart on the stand, make you look opportunistic or dishonest. Let them try. Rachel smiled. That's the spirit. But let's prepare you properly. They spent weeks practicing. Marcus played defense attorney, throwing every hostile question at her, every attempt to twist her words or undermine her credibility. He was good at it, too good. Some sessions left Maya shaken, doubting herself, wondering if she really was strong enough for this brutal examination. But she kept going. Every night, she reviewed transcripts of her practice testimony, identifying weak points, strengthening her answers, learning to stay calm under pressure. She wasn't naturally confrontational, but she was learning to stand her ground without becoming defensive. February arrived with cold rain and a headline that changed everything. Federal investigation launched into Blackwood Holdings. The Department of Labor had opened a formal investigation. So had the IRS. Blackwood was now fighting battles on multiple fronts, each one threatening to expose more of his business practices. His lawyers tried to delay the trial, arguing that the federal investigations created prejudicial circumstances that would unfairly influence the jury. Judge Harrison denied the motion curtly. You had years to address these issues, Mr. Pemberton. The trial date stands. Your client will face the consequences of his choices. March 3rd arrived faster than Maya expected. She woke at 5 in the morning, unable to sleep, her stomach knotted with anxiety that no amount of preparation could ease. Rachel had told her to wear something professional but not expensive. The jury needed to see her as relatable as one of them. She chose a simple gray dress, modest jewelry, minimal makeup. Looking in the mirror, she saw the same woman who'd walked into that courthouse 7 months ago, but different somehow. Stronger, steadier, more certain of her purpose. At the courthouse, media trucks lined 3 blocks, their satellite dishes pointed skyward like mechanical flowers. Protesters held signs supporting workers' rights, chanting slogans about justice and accountability. Counter-protesters, clearly hired based on their matching shirts and coordinated messaging, held signs defending Blackwood's right to run his business as he saw fit. Police maintained barriers between the groups, their presence a reminder of how much attention this case had drawn. Inside, the courtroom was packed beyond capacity, every seat filled and people standing along the back wall. The jury box sat empty, waiting. Judge Harrison had selected 12 jurors plus 4 alternates, a diverse group representing different ages, races, and backgrounds. Maya had studied their faces during selection, trying to imagine what they were thinking, whether they'd already formed opinions. Blackwood arrived surrounded by security, his legal team grown to 7 attorneys, each one a specialist in their field. Pemberton would lead the defense, but he brought in a trial attorney named Catherine Vance, known throughout the legal community for her aggressive cross-examination style and her ability to dismantle witnesses on the stand. Maya sat at the plaintiff's table between Rachel and one of the associate attorneys, her worn folder resting in front of her. Behind them, the gallery was filled with class members who'd come to watch, faces she recognized from photographs and phone calls. Jennifer was there, and Dorothy, and dozens of others. Their presence steadied her, reminded her why she was doing this. Judge Harrison entered. Everyone rose. The jury filed in, taking their seats with solemn expressions. This was real now. This was happening. Ladies and gentlemen, the judge began, we're here for the trial of Simmons versus Blackwood Holdings. This is a class action case involving allegations of systematic labor violations. Both sides will present evidence, and you will determine the truth based on that evidence alone. She turned to Rachel. Ms. Winter's opening statement. Rachel stood, buttoning her suit jacket, and approached the jury. She didn't use notes. She didn't need them. Members of the jury, this case is about a simple question. Do the laws that protect workers apply to everyone, or only to some people? Because for years, Ethan Blackwood operated under the assumption that those laws didn't apply to him, that he could pay people in cash to avoid taxes, that he could work them 70, 80 hours a week without overtime, that he could fire them if they complained, that he could make them disappear if they became problems. Rachel gestured toward Maya. Maya Simmons refused to disappear. She documented everything. She kept records. She studied the law. And when every lawyer she contacted told her it was hopeless to fight a billionaire, she represented herself. She did what many of you might have done if you were in her situation. She stood up. The jury watched Maya. She kept her expression calm, her posture straight. Over the next week, you'll hear from 14 witnesses who worked for Blackwood Holdings. You'll see evidence of systematic wage theft. You'll read internal emails proving that Mr. Blackwood knew his practices were illegal and chose to continue them anyway. You'll see a pattern of behavior designed to exploit vulnerable workers who thought they had no choice. Rachel paused, letting the words settle. The defense will argue that these were independent contractors, that they agreed to these arrangements, that nobody was forced to work there. But the law is clear. You can't contract out of labor protections. You can't ask someone to sign away their rights. And you certainly can't retaliate against people for asserting those rights. She looked directly at Blackwood. Maya Simmons did everything right. She documented, she reported, she followed every rule. Ethan Blackwood did everything wrong. He exploited, he intimidated, he retaliated. The evidence will prove it. And when you've seen all the evidence, we'll ask you to hold him accountable. Rachel returned to her seat. Maya squeezed her hand under the table. Catherine Vance stood for the defense. She was in her 50s with sharp features and sharper eyes. Her suit was impeccable, her heels clicking as she approached the jury. Ladies and gentlemen, you've just heard a compelling story. Stories are powerful. They pull at our emotions. They make us want to root for the underdog. But this trial isn't about stories. It's about facts. And the facts will show you something very different. Vance's voice was measured, reasonable. Maya Simmons made choices. She chose to accept cash payment. She chose not to request written contracts. She chose to work long hours because the compensation was good, better than she could get elsewhere. Those were her choices. And when she was terminated for legitimate performance reasons, she decided to reframe those choices as victimhood. Maya felt anger flash through her, hot and immediate. Rachel's hand tightened on hers, a reminder to stay calm. Mr. Blackwood is a successful businessman who employs hundreds of people. He's contributed millions to this community through taxes, charity, and job creation. He's not perfect, no one is. But he's not the villain the plaintiff wants you to see. He's a man who ran his household staff the way many wealthy people do, with informal arrangements that worked for everyone involved until Ms. Simmons decided they didn't work for her anymore. Vance gestured toward the defense table. You'll hear testimony from current employees who are happy with their positions. You'll see evidence that Ms. Simmons was repeatedly counseled about performance issues. You'll learn that her termination had nothing to do with retaliation and everything to do with her failure to meet the expectations of her position. She paused, her expression sympathetic. I understand why Ms. Simmons is upset. Losing a job is difficult, but being upset doesn't mean laws were broken. The evidence will show that Mr. Blackwood operated within the norms of residential employment, and that Ms. Simmons is simply an employee who didn't work out. Vance returned to her seat. Blackwood leaned back, his expression confident. The opening statement had been good, reasonable, measured, designed to make the jury question their assumptions. Judge Harrison looked at Rachel. Call your first witness. The plaintiff calls Maya Simmons. Maya stood. Her legs felt unsteady, but she walked to the witness stand without hesitation. The bailiff approached with a Bible. Do you swear to tell the truth, the whole truth, and nothing but the truth? Maya looked at the jury, at the gallery, at Blackwood watching her with calculating eyes. Ido. She sat. Rachel approached with a gentle smile, easing her into testimony with simple questions. Name. Background. how she came to work at the Riverside estate. The questions were designed to humanize her, to let the jury see her as a real person. Ms. Simmons, can you describe your typical workday at the estate? Maya took a breath. I started at 6 in the morning. I was responsible for cleaning the main house, which included 6 bedrooms, 8 bathrooms, the kitchen, dining room, living areas, and Mr. Blackwood's private office. I also did laundry for the household, prepared lunch, and assisted with dinner service when Mr. Blackwood had guests. What time did your workday typically end? It varied. On quiet days, maybe 7 or 8 at night. When there were guests or events, sometimes midnight or later. Did you receive breaks? 30 minutes for lunch if there was time. Days off. One day every 2 weeks, usually a Tuesday or Wednesday. Rachel walked her through the details methodically. Hours worked. Payment received. Calculations showing wages below minimum wage standards. The lack of written contracts. The verbal promises of taking care of her that never materialized. Ms. Simmons, why didn't you ask for proper documentation? I did. Multiple times. I was told that the estate operated on trust, that formal paperwork was unnecessary, that I should be grateful for the opportunity. What happened when you insisted? Maya's voice remained steady. I was told that if I wasn't happy with the arrangement, there were plenty of other people who would be. Did you feel free to leave? No. I was living at the estate. All my belongings were there. I had no savings because the wages were so low. If I left, I'd be homeless. Rachel let that sit with the jury, then moved to the termination. What happened on your last day? I was called in the head housekeeper's office and told my services were no longer needed. I had 4 hours to pack my belongings and leave the property. When I asked why, I was told it was a business decision. Had you received any warnings about your performance? No. I've been told repeatedly that I was doing excellent work. What did you think had changed? 3 days earlier, I'd asked again about getting proper employment documentation. I needed it to qualify for an apartment rental. I also mentioned that I'd been reading about labor laws and believed I should be receiving overtime pay. And 3 days later, you were fired? Yes. Rachel nodded. No further questions, Your Honor. Catherine Vance stood. This was the moment Maya had prepared for. The cross-examination that would determine whether the jury believed her. Vance approached slowly, her expression pleasant. Ms. Simmons, you said you worked long hours. Did anyone force you to work those hours? I was assigned duties that required those hours. But nobody physically forced you to complete them? Maya understood the trap. The expectation was clear. If the work wasn't done, I'd lose my position. So you chose to do the work to keep your job. That's how employment works, isn't it? When employment is legal, yes. Vance's smile tightened. You mentioned asking for documentation. How many times did you ask? 4 or 5 times over 18 months. 4 or 5. You're not certain? I'm certain it was more than once and less than 10 times. If this documentation was so important to you, why didn't you refuse to work until you received it? Because I needed the job. I needed the housing. I needed the money to care for my mother. So you made a choice. Continue working under arrangements you now claim were illegal, or leave. You chose to stay. Maya met her eyes. I chose to survive. That's different from choosing to be exploited. Several jurors nodded almost imperceptibly. Vance noticed and shifted tactics. Ms. Simmons, isn't it true that you were fired for repeatedly leaving Mr. Blackwood's office unlocked, creating a security risk? No, I was never told that. Isn't it true you frequently arrived late to work? No, I lived on the property. I was available 24 hours a day. Vance pulled out a document. I have here a memo from the head housekeeper dated 2 weeks before your termination. It lists several performance issues, including tardiness and incomplete work. Do you deny this memo exists? Rachel was on her feet. Objection. Foundation. The witness hasn't seen this document. Sustained. Ms. Vance, show the document to the witness first. Vance handed Maya the memo. She read it carefully. The date was accurate, 2 weeks before she was fired. But she'd never seen it before, never been counseled about these supposed issues. It had been created after the fact, she realized, backfilled to justify the termination. I've never seen this before, Maya said. None of these issues were ever raised with me. So you're saying this document is fake? I'm saying I was never counseled about these issues, never given an opportunity to correct them, never told my performance was unsatisfactory. This memo wasn't written for me. It was written for this lawsuit. Vance's expression hardened. You're suggesting my client fabricated evidence. I am stating facts. I never received this memo. Nobody ever discussed these issues with me. It's dated 2 weeks before I was fired, but I wasn't counseled or warned. That's not how legitimate employment terminations work. Judge Harrison leaned forward. Ms. Vance, do you have proof this memo was provided to Ms. Simmons at the time it was allegedly created? We have it in the personnel file. That's not what I asked. Did Ms. Simmons sign for it? Was it sent via email? Is there any proof she received it? Vance hesitated. Not in the traditional sense, Your Honor, but then move on. The cross-examination continued for another hour, but Vance had lost momentum. Every trap she set, Maya sidestepped with calm precision. Every attempt to paint her as opportunistic or dishonest bounced off the simple truth of her testimony. When it finally ended, Maya returned to the plaintiff's table exhausted but intact. Rachel squeezed her shoulder. You did great. The rest of the afternoon brought more witnesses. Jennifer testified about her experiences, her voice shaking but clear. Then Dorothy, then 3 others. Each story built on the last, creating a picture of systematic exploitation. By the time Judge Harrison adjourned for the day, the jury looked troubled. Several of them glanced at Blackwood with expressions that were no longer neutral. Outside the courthouse, reporters surrounded Maya. She prepared a statement with Rachel's help, something brief and measured. But standing there, watching the sun set over the courthouse steps, different words came out. I'm not special. I'm just someone who refused to disappear. If this trial does anything, I hope it reminds people that silence protects the wrong people. Speaking up is hard. Fighting back is scary. But it's the only way things change. That night, her words were everywhere. Social media, news websites, television broadcasts. Not because they were eloquent, but because they were true. In his penthouse across the city, Ethan Blackwood watched coverage of the trial on 3 different channels simultaneously. His lawyers were confident, telling him the case was going well, that Vance had damaged Maya's credibility. But Blackwood knew better. He'd seen the jury's faces. He'd watched them react to the testimony. They believed her. For the first time in his life, Ethan Blackwood realized he might actually lose. The trial's second day brought more witnesses. Jennifer Caldwell took the stand first, her hands trembling as she was sworn in. She wore a simple blue blouse and black pants, her hair pulled back in a style that reminded Maya of her own careful preparation. Rachel guided her through testimony gently, establishing the same pattern Maya had described: excessive hours, cash payments, sudden termination without cause or warning. Ms. Caldwell, you mentioned you kept photographs of your work schedule. Can you explain why you did that? Jennifer's voice was quiet but steady, growing stronger as she spoke. I'd heard about other people who'd been fired and then had their employment denied entirely, like they'd never worked there at all. Their names disappeared from records, their references were poisoned. They couldn't even prove they'd held the job. I thought if I had pictures, time-stamped pictures with visible details, I'd have proof I existed. Proof I'd been there. Proof of what they'd asked me to do. The jury leaned forward, several members taking notes. This was more than wage theft. This was systematic erasure of human beings. Vance tried to break her on cross-examination, her voice sharp and skeptical. She suggested the photographs were staged after the fact, doctored using editing software, or taken by someone else entirely. But Jennifer had prepared. She had metadata showing exact dates and times. She had timestamps verified by independent sources. She even had reflections visible in some photographs showing the estate's distinctive kitchen tiles, the same tiles visible in property listings and architectural magazines. Every attack bounced off documented truth. Every attempt to discredit her dissolved against evidence that couldn't be denied. Dorothy came next. She was 63, with silver hair and reading glasses on a chain around her neck. She'd raised 4 children while working at the estate, and spoke with the authority of someone who'd survived worse than any lawyer could throw at her. Her testimony was devastating in its simplicity. They told me I was family, Dorothy testified, her voice carrying to every corner of the courtroom. Mr. Blackwood himself said it once at a Christmas party. He came through the kitchen where the staff was eating after we'd served the guests. Said we were all family, that he appreciated our loyalty, that we'd always have a place with him. But family doesn't pay you under the table so they can avoid taxes. Family doesn't threaten you when you ask for proper documentation. Family doesn't throw you out of your home with 4 hours notice and nowhere to go when you mention the word lawyer. Several jurors looked directly at Blackwood after that. Their expressions had shifted from neutral interest to something harder, colder. By the third day, the pattern was undeniable. Witness after witness described the same system, the same exploitation, the same fear that had kept them silent for years. A young man named Marcus, different from the investigator, sharing only a first name, testified about working 90-hour weeks during event seasons with no additional compensation. A woman named Lisa described being fired 3 days after asking about health insurance for her diabetic daughter. Blackwood's attorneys tried to paint each one as disgruntled or opportunistic, as people looking for easy money or nursing grudges. But the consistency was damning. These people didn't know each other before the lawsuit. They'd worked at different times, at different properties, under different supervisors. Yet their stories overlapped perfectly, like pieces of a puzzle that revealed a clear picture of systematic abuse. On day 4, the defense called their witnesses, current employees who testified that they were happy, well-treated, properly compensated. But under Rachel's cross-examination, cracks appeared. Mr. Phillips, you testified that you're satisfied with your employment. Are you aware that this trial is happening? Yes. Are you aware that Mr. Blackwood is in this courtroom watching you testify? Yes. Would you feel comfortable testifying differently if you thought it might cost you your job? Pemberton objected. Judge Harrison overruled. The witness didn't answer, but his silence spoke volumes. The financial evidence came next. Marcus had worked with a forensic accountant who'd analyzed every document produced in discovery. The numbers told a brutal story. Blackwood had saved an estimated $12 million over 8 years by avoiding payroll taxes, overtime, and proper wages. $12 million, Rachel repeated during her questioning of the accountant. That's not a rounding error. That's not a bookkeeping mistake. That's a systematic strategy to profit from exploitation. Blackwood's corporate accountant took the stand, clearly uncomfortable. Under oath, he confirmed that he'd warned Blackwood 3 years ago about legal exposure. He'd recommended immediate corrective action. Blackwood had declined. Did Mr. Blackwood give a reason for declining? Rachel asked. He said it would be too expensive to fix, too expensive to follow the law. That's what he said. The courtroom was silent. Even Vance seemed to have no follow-up questions. On day 6, Rachel rested the plaintiff's case. The evidence was overwhelming. Testimony from 14 witnesses, financial documentation proving millions in wage theft, internal emails showing consciousness of guilt, and expert testimony establishing that every element of the class claims had been proven. Pemberton spent day 7 trying to salvage the defense. He argued that the workers had agreed to the arrangements, that they benefited from cash payments that avoided taxes, that nobody had been forced to stay. But his arguments felt hollow against the weight of evidence. Closing arguments came on day 8. Rachel stood before the jury, speaking without notes. Members of the jury, you've heard 8 days of testimony. You've seen the evidence. You know the truth. Ethan Blackwood built part of his fortune on the backs of workers who had no power, no options, and no voice. He knew what he was doing was illegal. He was warned. He didn't care. She gestured toward Maya. Maya Simmons gave him a voice. She gave all these workers a voice. She documented everything because she knew that without proof, she'd be dismissed. She studied the law because she knew that without knowledge, she'd be defeated. She stood alone in a courtroom because she knew that silence was the same as surrender. Rachel's voice grew stronger. The defense wants you to believe these were voluntary arrangements. But there's nothing voluntary about exploitation. There's nothing consensual about taking advantage of people who need work, need housing, need to survive. Mr. Blackwood had all the power. These workers had none. That's not an agreement. That's coercion. She paused, letting the words settle. We're asking you to hold him accountable, not just with a verdict, but with damages that reflect the scope of what he did. $12 million in wages stolen. 73 people exploited. 8 years of knowing violations. The law allows you to award punitive damages when someone acts with conscious disregard for the rights of others. If this case doesn't qualify, nothing does. Vance's closing was professional, measured, but the fire was gone. She knew they were losing. She argued that the plaintiffs had exaggerated, that the evidence was circumstantial, that Blackwood was a businessman, not a villain. But her words felt like reading from a script she no longer believed. Judge Harrison gave the jury their instructions. You must determine whether Blackwood Holdings violated federal and state labor laws. If you find they did, you must calculate damages, both compensatory for the wages owed and potentially punitive to punish and deter future violations. The jury retired to deliberate. Maya, Rachel, and the team returned to the coalition office to wait. The class members gathered there too, dozens of people who'd come to represent hope for something better. Hours passed. Maya couldn't eat, couldn't focus. She kept replaying moments from the trial, wondering if they'd done enough, if the jury had believed them. At 4:30 in the afternoon, Rachel's phone rang. She looked at the screen, then at Maya. The jury has reached a verdict. The room went silent. After only 6 hours of deliberation, they had an answer. They rushed back to the courthouse through late afternoon traffic, Rachel driving while Maya sat in the passenger seat, trying to control her breathing. Marcus followed in another car with several class members. Others were calling people, spreading the word. By the time they arrived, a crowd had gathered. Media had multiplied, sensing the end was near. Camera crews lined the courthouse steps 3 deep. Maya walked through camera flashes and shouted questions, her heart hammering so hard she thought people must be able to see it through her dress. Rachel's hand was on her elbow, steadying her, guiding her through the chaos. Inside, the courtroom filled quickly, people squeezing into every available space. The bailiffs had to turn people away at the doors, the gallery packed beyond what fire codes probably allowed. Blackwood sat at the defense table, his expression carved from stone. His face was pale, his jaw clenched so tight Maya could see the muscle jumping. His attorneys flanked him, their body language tense, folders and papers arranged and rearranged nervously. The jury filed in. Maya tried to read their faces, searching for any hint of what they decided, but they were carefully neutral. They'd been instructed not to reveal anything before the verdict was read, and they followed those instructions perfectly. Judge Harrison asked the foreperson, a middle-aged black woman who worked as a nurse, if they'd reached a verdict. We have, Your Honor. On the claim of wrongful termination, how do you find? We find for the plaintiffs. Maya felt Rachel's hand grip hers so tightly it almost hurt. On the claim of wage theft, for the plaintiffs. The grip tightened. Someone behind them made a small sound, quickly stifled. On the claim of retaliation, for the plaintiffs. On the claim of labor law violations, for the plaintiffs. Maya's vision blurred with tears. She tried to blink them away, tried to stay composed, but they came anyway. Around her, class members were crying, holding each other, mouths open in stunned disbelief that this was real, that they'd actually won. Have you calculated damages? Yes, Your Honor. The foreperson consulted her notes. We award compensatory damages in the amount of $14,200,000. The courtroom erupted in gasps, in exclamations, in sounds of shock and vindication. Judge Harrison's gavel came down sharply, the sound cracking through the noise. Order. I will have order in this courtroom. The noise subsided to tense silence. The foreperson continued, her voice steady and clear. Additionally, she said, looking directly at Blackwood, we award punitive damages in the amount of $35 million. This time the eruption couldn't be contained. $49 million total. It was staggering. It was justice made real, given weight and substance and consequence. Blackwood's face had gone white. Pemberton was already whispering urgently to him, no doubt discussing appeals. But it didn't matter. The verdict was in. The jury had spoken. Judge Harrison addressed the courtroom. The jury has rendered its verdict. Mr. Pemberton, I assume you'll file post-trial motions. You have 30 days. This court is adjourned. The gavel fell for the final time. Maya stood there, unable to move. People were hugging her, congratulating her, crying. Rachel pulled her into a tight embrace. You did it. You actually did it. We did it, Maya whispered back. Outside, reporters surrounded them. Rachel had prepared a statement, but Maya asked to speak. She stood on the courthouse steps, the same steps she climbed alone 7 months ago. This verdict isn't about me. It's about every person who's ever been told they don't matter, that they should be grateful for whatever scraps they're given, that fighting back is hopeless. It's about proving that the law applies to everyone, even billionaires who think they're above it. She looked directly at the nearest camera. To everyone watching who's been exploited, who's been silenced, who's been made to feel powerless, you're not. You matter. Your work matters. Your dignity matters. And the system, as broken as it sometimes is, can still work if you refuse to give up. The news coverage that night was massive. The verdict led every broadcast, every website, every paper. Maid wins $49 million against Billionaire became the story that dominated headlines for days. But the consequences extended far beyond the verdict, rippling outward in ways that would reshape entire industries. Within a week, 3 of Blackwood's major investors pulled out, their statements carefully worded, but their meaning clear. They couldn't be associated with someone found guilty of systematic labor exploitation. His stock in various holdings plummeted, losing 40% of its value in 3 trading days. Business partners who'd ignored the lawsuit, who'd assumed he'd win or settle quietly, suddenly couldn't afford to be associated with him. Projects in development were abandoned. Contracts were terminated. The real estate empire he'd built over 3 decades began cracking apart, like a building with a flawed foundation. The federal investigations intensified with renewed vigor. The Department of Labor imposed additional fines totaling $8 million for violations found at his other properties. The IRS launched a criminal investigation into tax evasion, and federal prosecutors who'd been watching the civil trial suddenly became very interested in filing charges. State labor boards in 3 states opened inquiries into his other properties, each one finding similar patterns of abuse. Blackwood's empire, built over 30 years through a combination of legitimate business and systematic exploitation, began cracking apart. Projects stalled midway through construction. Executives resigned, some providing damaging testimony to investigators in exchange for immunity. His name, once synonymous with luxury and success, became shorthand for exploitation and greed. Business schools started using his case as an example of what not to do, of how hubris and disregard for the law could destroy everything. 2 weeks after the verdict, Blackwood Holdings filed for Chapter 11 bankruptcy protection. The company would be restructured, assets liquidated to pay the judgment and mounting fines. Ethan Blackwood stepped down as CEO under pressure from the board, releasing a statement that took no responsibility and admitted no wrongdoing, blaming the verdict on an unfair legal system that punishes success. Maya watched the news in her studio apartment, the one the coalition had helped her find. The apartment wasn't much. A single room with a kitchenette tucked into one corner and a bathroom barely big enough to turn around in. The walls were thin, the heating inconsistent, the view facing a brick wall. But it was hers. Safe. Stable. A place where nobody could force her to leave, where she controlled her own space, her own life, her own future. The settlement distribution took months to process, lawyers and accountants working through the complexity of dividing the award among 73 class members. Eventually, each class member received their share, amounts varying based on how long they'd worked and how much they were owed. For some, it was enough to pay off crushing debt that had accumulated during unemployment. For others, the down payment on a house, the first step toward real stability. For Dorothy, it meant retirement security she'd never thought possible, enough to live comfortably without worrying about every dollar. Maya's share, as lead plaintiff with 18 months of documented exploitation and extensive participation in the litigation, came to $470,000. After taxes and the legal fees that even pro bono cases incurred, she had enough to live on for years while she figured out what came next. It was more money than she'd ever imagined having, and it felt both liberating and overwhelming. Law firms reached out almost immediately, offering jobs or sponsorship for law school. Advocacy groups wanted her to join their boards, lending her name and story to their fundraising efforts. Media outlets requested interviews, wanting to profile her journey from Maid to Victor. Speaking engagements offered thousands of dollars for an hour of her time. Everyone wanted a piece of the maid who took down a billionaire, wanted to be associated with her success, wanted to claim some connection to her story. She declined most of them. The attention felt wrong somehow, like she was being celebrated for simply refusing to disappear. Like her struggle was being commodified, turned into inspiration porn for people who'd never faced what she'd faced. But there was one offer she accepted, one that felt right in a way the others didn't. The Workers' Justice Coalition needed a community outreach coordinator, someone who could talk to workers facing exploitation, who understood what it meant to fight back without resources, without connections, without hope. Someone who knew what it felt like to walk into a courthouse alone and face a system designed to favor the powerful. Someone who could look a scared worker in the eye and say, "I know exactly what you're going through," and mean it completely. "I'm not a lawyer," Maya said when Rachel offered her the position over coffee at a cafe near the coalition office. "No, but you understand something most lawyers never learn, what it costs to stand up. The real cost, not the theoretical one we read about in case studies. We need that perspective. We need someone who's lived it." Maya started in September. Her job was simple in concept, but profound in impact. Talk to workers, document their stories, connect them with resources, and help them understand that they weren't alone. She became the person she needed 7 months ago, the voice telling others that fighting back was possible, that the system could work, that their dignity mattered. She also enrolled in community college, taking paralegal courses at night while working days at the coalition. The classes were challenging, forcing her to learn concepts that had taken her months to figure out on her own. Maybe someday she'd go to law school properly, earn that degree, and pass the bar. Maybe not, but she wanted to understand the system better, to be more effective in helping others navigate its complexities and traps. One evening in October, she was working late at the coalition office when her phone rang. Unknown number. She almost didn't answer, but something made her pick up. "Ms. Simmons? My name is Patricia Reeves. I clean offices in the financial district. I saw your case on the news. My boss, he's doing the same things. Cash payments, no contracts, crazy hours. I kept records like you did. Can you help me?" Maya pulled out a notebook. "Tell me everything." That became her new routine. Phone calls from workers who'd found courage in her story. Meetings with people who'd documented their own exploitation, who'd learned from her example. The case against Blackwood had been the beginning, not the end. By December, the coalition had filed 4 new class actions based on cases Maya helped develop. Other firms, seeing the success, took on labor cases they'd previously ignored. The legal landscape was shifting. Maya heard about Blackwood occasionally. He'd moved to a smaller home, downsized his life considerably. The criminal tax case was still pending. His reputation was destroyed beyond repair. She felt no satisfaction in his fall. She'd never wanted revenge. She'd wanted accountability. There was a difference. One cold afternoon in January, nearly a year after she'd first walked into that courthouse, Maya returned there for a different reason. A young woman, Hispanic, mid-20s, had filed a wage theft claim against a restaurant chain. She was representing herself. The coalition was advising her, but she'd insisted on being the voice of her own case. Maya sat in the gallery, watching. The woman was nervous, her voice shaking as she presented evidence. The defense attorney was dismissive, confident. The judge looked skeptical. It was like watching herself a year ago. After the hearing, Maya waited outside. The woman emerged looking shaken but determined. "Excuse me," Maya said. "My name is Maya Simmons. I wanted to tell you that you did well in there." The woman's eyes widened. You're the one who sued Blackwood." "I am. And you're doing exactly what I did, standing up when it's terrifying. That takes real courage." "I don't feel courageous. I feel like I'm going to throw up." Maya smiled. "That's what courage feels like. Not the absence of fear, but doing it anyway." She handed her a card. "This is the Workers' Justice Coalition. If you need help, call. There are people who want to support you." The woman took the card with trembling hands. "Thank you. I thought I was alone." "You're not. None of us are. Not anymore." Maya walked away, leaving the woman on the courthouse steps. She thought about all the steps that had led here. Her mother's death, her time at the estate, the documentation, the lonely nights studying law, the terror of that first hearing. Each moment had felt impossible. Each decision had required everything she had. But she'd made it through. Not just survived, but created something larger than herself. A reminder that the system could work. That power could be challenged. That one voice, speaking truth, could start an avalanche. Her phone buzzed. Another worker seeking help. Another person finding courage. Another story waiting to be told. She answered, "This is Maya. Tell me what happened." And she listened, because that's what it was really about. Not the verdict, not the money, not the headlines. It was about people being heard when the world had trained them to be silent. It was about dignity in a system designed to strip it away. It was about the quiet revolution that happened every time someone refused to disappear. Maya Simmons had been a maid. She'd been dismissed, underestimated, expected to fail. She'd walked into a courtroom with nothing but a worn folder and an unwillingness to accept injustice. She'd stood alone against a billionaire who'd laughed at her. By the time the courtroom emptied and the verdict was read and the empire crumbled, she was the only one still standing. Not because she was extraordinary, not because she was special, but because she'd refused to be invisible. And in that refusal, she'd changed everything. 3 years later, Maya graduated from law school. Rachel was there, along with Jennifer, Dorothy, and dozens of class members who become friends. The Workers' Justice Coalition had grown, handling hundreds of labor cases, helping thousands of workers. The Blackwood case had become required reading in law schools, a case study in class action litigation, in David versus Goliath battles, in what happens when a system actually works. Ethan Blackwood had been convicted of tax evasion and sentenced to 18 months in federal prison. His business empire was gone, liquidated to pay judgments and fines. He would be released eventually, but he'd never recover what he'd lost. Maya didn't attend his sentencing. She had more important work to do. On the day she passed the bar exam, she received a letter. No return address, but she recognized the handwriting. Neat, careful, the handwriting of someone who'd learned to document everything. Inside was a single sentence. "Thank you for showing me I could fight back. I won." It was from another worker, another case, another battle. Maya added it to the box where she kept such letters. There were hundreds now. She looked at them sometimes, when the work felt overwhelming, when the system felt broken, when she wondered if any of it mattered. Then she'd remember that courthouse, that folder, that moment when a billionaire laughed at her. And she'd remember what she'd learned. That justice doesn't belong to the powerful. It belongs to anyone brave enough to demand it. Maya Simmons had been a maid. Now she was an attorney. But more than that, she was living proof that refusing to disappear could change the world. One voice at a time, one case at a time, one victory at a time. The woman who stood alone had shown thousands of others that they could stand too. And that, in the end, was worth more than any verdict. When someone with all the power in the world tells you to stay silent, what does it cost you to speak up? And what does it cost you not to? If this story moved you, hit that like button and subscribe for more stories about ordinary people who refuse to stay ordinary.